Yo, what's going on, beautiful people? Man, peace, love, and law to each and every last one of you, and all praise to the Most High for this beautiful day. Welcome to In God We Trust Academy podcast today. And just hope everybody's having a great and beautiful day, man. And just y'all be safe out there, though. You know, it is the Independence Time Day of the United States, right? And you know how they do with those troopers out there. We're going to talk about a few things today as far as trustee duties and just a few pointers on what to do and how to handle yourself while you're out this weekend, and just being aware and more knowledgeable about your situations that's going to be going on. I don't have a food stamp, so you might want to get with Wizard Kelly for that. You didn't ask me twice, but I don't have that. It's not my class. But yeah, man, it's been a beautiful time, man, and just ready to get this thing rocking and rolling and keep on strolling for us, man. And hope everybody's in good spirits and just able and ready to continue to move forward. All right, guys. So as you know, July the 26th, all right, we have a trust administration class coming up for you guys, and we will be on Fort Walton Beach, which is 15-20 minutes next to Destin, Florida, if you're familiar of the area. But we're going to be there and teaching you guys about trust administration. So it's $200 for the live stream, $250 in person. The deadline is the 25th for the live stream, 23rd for in person, right? You can go to ingodwetrustacademy.com to be able to log in with us. And also we got the Hidden Ledger class, which is 2 weeks after, August the 9th, and we will be in Houston, all right, as well. So we're going to be talking about these things a little bit more today. And also right now available, we have a course on Teachable right now that you guys can go to, and you can literally be able to go to this course. It's a debt liberation course here. And those of you that are interested in this course, you're more than welcome. I'll tell you how to get to that before the day is over with. But very dope time to be alive, though, man. Shout out to everybody and all of y'all participation, as always. So anything that you hear from this point forward is for educational or religious purposes only, guys. This is not legal advice. Please do seek a legal advisor. All right, that's what I want you guys to do. Go and get you a legal advisor, because I am not giving legal advice. All right, so if you see the screen right now, this is the debt class that I was talking about. You can go to In God We Trust Academy, teachable.com. We have a course on there right now, $350. It's about 6 classes in all. The powerful course teaches you how to beat third-party debt collectors, lawfully discharge debt without using money, and exit contracts through breach. You'll learn how to set off obligations, redeem debt using lawful method, and expose how banks act as debtors, not creditors. And discover how mortgages are prepaid through your promissory note and how to discharge them lawfully. This is not about theory. It's about real legal remedies rooted in contract law, equity, commercial truth. If you're ready to cancel debt and to protect your assets, guys, this would be the class for you. If you're interested, again, it's on teachable.com. Has about, let's see, I'll expand it so you guys can actually see the class. So, yeah, you got 1, 2, 3, 4, 5, 6, 7, 8, 9. So you got about 10 classes there. 10 classes. Some of them are ebooks that goes with the classes, but for the most part, it's 10 classes there for you guys to fully learn how to do these things. No, you don't need negotiable instruments and all of that stuff. You just need to understand the law. And if you understand the law, then you're going to be able to operate. Now, this is what I want to say about trustee duties today, because no matter what situation you are in, you are basically the trustee of your life. Okay, you are entrusting yourself to make the decisions that you're supposed to make with your own life. Now, the thing is how good of a trustee are you? Are you really being a great trustee? That's the question that we have to ask you guys, because truth is, I don't think so. I don't think people are actually taking control of their life the way they are supposed to, right? Gotta know, gotta know, gotta know. All right, so when it comes to this, your trustee duties, right? Most people set up a trust and think paperwork alone is just going to protect you. But a trust only works if the trustee knows how to enforce it. And I can think of so many people, it's probably about a few of you watching me right now, that has no idea on how to operate your trust that you have. You probably got all kind of different assets that you convey to it, etc., but you still don't understand the concept of administrating, and record keeping is one of the main things in this whole entire situation, right? Most people don't understand the difference between the legal title and the equitable title, and how to always operate from the trustee perspective. And you don't own anything. You're only controlling, right? Courts, banks, or government agencies won't care about you or a trust if you don't prove your authority. Okay, so the trust administration class is going to teach you how to stop being passive, because a lot of you are so passive, right? Because when someone tries to seize, tax, or foreclose on your trust property, your silence is taken as consent. And this knowledge turns your trust into a legal fortress, right? Literally keeps everything from being able to pierce your trust. And you don't want that to happen. So you need to be mindful. Remember, this is estate planning. So what's your plan? What kind of plan do you have to continue to generate, create wealth? But not only that, because everybody just into generating and creating the wealth, but can you protect the assets from any form of endangerment that may or come from other third parties, et cetera, right? Can you do that? And you must know how, right? Because if not, if you don't act on those things, they will be taken from you, right? So legal title gives the trustee the right of control, okay? The right to control, manage, and defend the property. That's what you gotta know, okay? It gives you that, right? So you also have to understand that equitable title belongs to the beneficiaries, but it only gives them the right to benefit, not to act. So that means that anything that's going to take place, you guys need to learn how to act specifically from the trust perspective. The only way the beneficiary can ever act is based upon the trustee failing to do something and act on the actual obligations that they're supposed to fulfill. Okay? The actual legal title is a title that the court will always recognize. When we say legal, you got to know that it's a contract that's involved in order for this to take place. So you got to know when and also how to literally intervene. So you're going to learn how to show courts, banks, or adversaries that you are the only lawful party withstanding, and why beneficiaries cannot file or defend on behalf of the trust. They really can't, especially when the trust owns the property. Now, if you guys start doing stuff to where you start distributing things to the beneficiary as outright ownership, now the beneficiary owns that particular property and they can go. But however, it also means that if the beneficiary is the one that they're looking to seize property from, then there's really no protection for you. They can literally come and just take it. That's what they can absolutely do. So me, myself, personally, I always choose to allow the trust to own the particular property, right? And for them to take that property, and the trust protects the property. The only thing is that the trustee is in control over it. It has the right to use any form of property of the trust for administrative purposes of the actual trust. And or if you are the beneficiary, you do not own it. You just have the right to benefit from it. That's it. Nothing else. So when somebody files a lawsuit, foreclosure, or a lien against your trust property, the trustee has a duty to step in immediately. If you wait, courts can make decisions without you. And it's going to put a whole lot more pressure on you to go back, open up the case, to do this, to do all these different other things that you're just not going to have to do. So this class is going to help you walk you through exactly when intervention is necessary for foreclosure notices, creditor lawsuits, government seizures, and partition actions on like real estate and stuff like that. So you're gonna literally practice on drafting your own motions to intervene so you can quickly file into a case that will be affecting your trust property. A lot of people do not know that. You have to, and that's one thing I always say, the rules and procedures of the court. You got to know it. If you don't know the rules and procedures of the court, then just be prepared to always be taken fully advantage of, because that's what's going to happen. They're going to literally do what they want to with you, and you must know the rules. A lot of people know certain laws and stuff like that, or you got the idea of how things supposed to work, but you do not have the procedure and administration down pat, and that's where you're going to lose and fail at, right? So you're going to need to make sure that we're doing everything the absolute correct way. Courts, when it comes to courts, evidence, we need proofs. One of my principles that I say is truth, proof, law, and relief. So we need the truth, okay? Truth, proof, law, and relief. The truth always comes with the affidavit. We got the proof, which is the legal title, and we're going to use the law where you are fully protected in the rights and interests of your property. All right. And then we're going to ask to be granted the relief. Okay. So courts look for proof of authority, such as affidavits, resolutions, and also certificates of trust. All of these show delegation of authority and proof of ownership or rights and interests of use. So we're going to also show you how trustee affidavits proving your fiduciary role, how certificate of trust shows that the trust exists and you can control it. All right. We're also going to be showing you that the trustee resolutions to document decisions internally. So just like a corporate board of minutes, especially for those of you that are running family trusts and that you have multiple beneficiaries and things of that nature. I'm not beneficiaries, but multiple trustees. All right. You might have a board of trustees. And certain things that has to be done and given, powers given to individuals to be able to go fully act within certain places. Because this is the same way we challenge attorneys. If attorney can't show that a corporation has went to the board and delegated the authority to this attorney to operate on behalf of the company, then we can actually have that lawyer removed from the case. Same situation that will be with you if you don't show proof of authority for you to be able to act as a trustee on behalf of the trust. So usually that could be done in a certificate of trust. It could also be done in a form of, if like I say, if you got a board of trustees, then you have to have that delegation of authority coming from the board of trustees in order for you to be able to operate. Otherwise, someone like myself would challenge that in court and tell you to show proof of delegation of authority coming from the actual board of trustees and trustee minutes that you were given the authority to operate on behalf. I would definitely challenge that, right? And if you can't prove that, then that is literally going to get you thrown from the case. You have no delegation of authority, so there's no cause of action here to grant relief. And that's what I would do. So you got to always make sure that your record keeping is on tight, on point, right? And that's what I wanted to help you to do. As we did the declaration of trust class a few weeks ago, is that's one of the things that I showed you is that your record keeping has to be on point. Excuse me. With everything that you are doing, you have to know. If you don't know, then that's where the problems are going to come in for you, right? You have to be very, very well kept when it comes to these records, right? Also, without these documents, guys, a judge can dismiss your motions or creditors can argue your trust is invalid, or it don't mean your trust is really invalid. You just don't have the delegation of authority to operate. All right. So you also need to learn how to move disputes into private arbitration. Public courts expose your trust to biased rulings, public records, and huge legal fees. Arbitration keeps matters private, faster, and often fairer, and forces the other party out of court if the trust has an arbitration clause. So you can literally create arbitration clause within your declarations of trust. And what this does is anything that comes up with the trust, any disputes that's happening with the trust properties and things like that, it literally has to go into a form of arbitration, and it does not have to be, you can literally get it removed from that court. Because again, Article 1, Section 10, the states cannot create any laws impairing the obligations of contract. Well, a trust is a full contract, and it's literally governed under contract law. So with that being said, if there's an arbitration clause within the trust, declaration of trust, then the court will literally lose jurisdiction, and from that point on, they have to literally remove, dismiss that case, and demand that it goes back to go into arbitration for the dispute of the property. That's what it has to do. So it would have to literally exhaust all remedies, right? So just remember that, all right? You'll learn how to add or enforce arbitration clauses in your trust and how to issue a demand for arbitration that stops court proceeding, all right? And you will also get how arbitration awards that can be turned into judgments to enforce your rights. So when you do get a judgment, guys, you also need to learn how to go and get a money judgment, right? How to enforce a money judgment, because a lot of people can get money judgments all day, but if you don't know how to enforce it, then that's where you lose. Got to know how to do that, right? Got to know how to do that. So I would really say, like, as a trustee, if you're going to be a trustee, like I say, a lot of you guys think it's just putting a trust together and then you're just there, right? But you literally have to know and be aware of law, the rules and procedures of courts. You have to be fully aware of all contracts that are entered into, along with the trust or grantor beneficiary or any rights or interests that has been transferred over until the trust. It takes the trustee to have full knowledge. If the trustee does not have the full knowledge, the trustee needs to also be well prepared to be able to do what you call a limited power of attorney to a attorney to represent the trust on anything that needs to be done, far as damages or things like that, constructive trust that has taken place for the trust. So you need to sit down and ask yourself, yes, I know you got a trust, but are you aware of these things? And are you capable of literally protecting the trust assets? Because if you are not, the problem comes in, and here we are. You're not ready, and they're going to take your stuff. They're going to do what they call a control test. And if they find out any shape, form, or fashion that they have jurisdiction based upon 3 to 4 different ways, then what they're going to do is they're going to pierce the trust. And a lot of you guys have revocable trust, all right? And that revocable trust, which is like a grantor's trust, which literally means the grantor still has rights and interests into that particular property. So let's say that particular grantor is being sued. Well, if that grantor is being sued, then guess what? They can literally pierce that trust because that grantor still has rights and interests into the property. All right. Now, grantor trust, revocable trust, it's not a bad thing. I don't want to say that it is or ain't, but those things that you do in those type of trusts literally needs to be assets that you're willing to move in and out. You're transferring some type of form of property quickly or something like that. When it's assets that you really fully want to protect in every single way, irrevocable is the way to go, because now you have no rights or interests in that particular property as a grantor. It strictly belongs to the trust. And if it strictly belongs to the trust has full ownership, and the trustee has control, and the beneficiary only has the enjoyment to act. That's it. I mean, the act of enjoyment to it. Okay, that's it. That's where you want to be at. Now, again, I myself don't do revocable because I truly understand that every conveyance is a trust. So if I do a conveyance, it is like its own type of trust with this particular property. I'm giving it to the trustee for the benefit of another, and I'm stating what I want to happen with this particular property in this trust. And when I do that as the grantor, I'm relinquishing all rights to the trust. It now belongs to the trust. And now the trust, if you've done everything right, accordingly in the declaration of trust, and all the powers that you have given the trustee Well, the trustee still has all the power to do everything that the grantor did as if it was the owner of it at the time, right? So, what's the difference if you're going to be the trustee? You're still in control over it. It's still yours to convey, sell, sign, whatever you may choose to do from it from the trustee position, which is always going to give you that particular power. That and still, you don't want to say that you are the owner of it, right? You're just in control over it and administrating for the trust, which also means now that you hold no form of liability to it as a trustee. That's the place that you want to sit and be with these type of things. All right. Because if not, then like I said, it leaves the door open for your trust to be pierced. And you really don't want that to happen, right? You really don't want that to happen. So, with that being said, you must learn to truly operate from a trustee position. And has been a trend. It's definitely been trending over the past, real hard, probably the past 6 years for me that I've seen that this whole trust thing is trending. It's trending so hard that people, hey, get a trust, get a trust, get a trust, get a trust. Like, listen, having a trust does not mean anything if you don't have the power to literally operate it. And it don't necessarily, you might not want to operate it yourself. You might want to go hire you a trustee to fully operate it and just make sure that they're aware and know exactly what to do. Right? Because some people just don't actually have the time. And I get that. But it's still to be fully aware. That's just like I tell people when you go in to hire a lawyer or something of that nature, like it's still best for you to understand truly the rules and procedures of the court and everything of that nature. It's better for you to know. It's better for you to know your own rights. I didn't necessarily say that you have to go and do it, but you would be aware of negligence if an attorney, if you as a trustee had to give limited power of attorney to a lawyer or whatever the case may be, and they had to go and represent the trust on your behalf, because now that means now they're going to bring it in the name of the trust. So you have to have a lawyer if you go and bring something in the name of the trust. Okay. So with that being said, you need to make sure that you know if a lawyer is neglecting you, because they can do that. They can literally neglect you by not filing and operating according to the rules and procedures of the court. And they might miss something, they might skip something that's going to cause you harm. And if you're not aware of that, then that's something that you can't claim, because there is a huge thing about lawyers neglecting their clients. And now you're able to do a full retrial based on it, right? So just make sure that we're aware of these things. This is way bigger than just slapping a trust together. This is literally being still more informed about in the law, understanding the rights and the rights of the trust as well. Because everything that a living being has, as far as inalienable rights, etc., so does the trust once you pass the rights and interests on to it. It still has those same things. It can sue and be sued. It can own property. It can sell property. It can do all kind of different things, right? And it still can operate from the common law, because this is not created by the actual state. It's actually created by the people themselves through contract, right? Which is literally goes back to the common law itself. So you need to fully know that, okay? You need to fully, truly understand that. And also, if the trust is set up right, it's automatically considered in the form of a foreign state to the United States. Yes, that is absolutely true, right? You can literally set it up. Now, you can also do this with what they call a 508. A 508 is literally like a church, right? It's a private religious type church. It's not a 501c3 like a public entity that you got to go register and, to be able to receive benefits, et cetera. Like, no, a 508 is already tax exempt, and any auxiliaries that's attached to this 508. So that means if a church is created from this 508, it's tax exempt. If you start a school or any businesses or anything like that in relations to this 508, because now, and a lot of people are like, well, if we start a business, wouldn't that put it in the realm of, to the state and things like that? No, because it's about what you do with the money. If the money that is being made from the business is automatically being assigned and conveyed into the to the 508 or to the trust of the 508, then automatically it's still tax exempt in every way possible because it's for religious purposes. So it could be to feed the church, the general welfare of the church, the infrastructure, or anything of that nature, right? This is how you really want to operate. And I say this because, well, especially down here in the South, what they call the Bible Belt, it's literally super on the religious side, just down this way. And I just don't understand why a lot of churches, well, one, I do know, they don't have the knowledge and resources of this type of information to understand what they would do. Otherwise, it would be so many different type of churches that would operate in this particular manner, which is why I say when operating in this way, you could give the house, you could give the cars, you could give everything to your 508. And that 508 literally gives the equitable title back to the people to be able to what? Use it. They don't own it. They just in control of it, right? I mean, in the use of it. And the trustees are controlling it, right? So you could literally make the 508 the trustee over the actual trust that you're going to create. Or the 508 is a trust within itself, as to be honest with you. But you can do it that way. And when you do it that way, now everybody houses, all members of the 508. If you gave your house to the 508, tax exempt. There's no more taxation on it at all. Now, you would say, how is this so? Well, do you pray at home? Do you fellowship at home? Do you study at home? Do you, everybody should be eat according to their religious diet anyway, whatever that may be for you, right? We got to understand all things come from God, right? If that's your perspective of life. So if you look at it from that standpoint, then why are you not fully operating in the religious aspect, which will literally protect your property? I go back to in the scripture where it was talking about bring everything to the storehouse. And that's basically what the trust is. The trust is the storehouse. Bring everything into the storehouse and it will be given back unto the people, right? In an equitable exchange. It does not even belong to the people, right? It belongs within the trust or the 508, either or, right? Doesn't matter. But at the end of the day, that's what it's for. And when you start operating in that manner, now that gives the 508 or to come in as the trustee to protect the assets. So let's say someone was towing a car. Like let's say your car was being towed. It's the duty of the trustee or the 508, any individual that's within it that has been there. Because now if you operate on the 508, you got to go back, make sure that you give the individual that's going to represent the trust property that they have to have delegation of authority. Same way lawyers do have to do with corporations if they're going to do something and suing or representing that particular corporation. They have to be given the authority. Same situation. So once you do that, now that particular individual will need to learn how to do a motion to intervene to literally protect the trust assets. Now, the fact that it's used for religious purposes, first and foremost, that's first in line because that takes us back to the First Amendment. The First Amendment says what? That they cannot create any laws prohibiting the free exercise of religion. So what is that? Your free exercise of religion. That could be you. It could be anything, man. Like, you know what I'm saying? Like whatever you want to consider it to being with your car. So they can't take and tow your car, and which takes away your religious practices, right? They would literally have to return it to the owner. And that means a trustee of the particular 508 or the trustee of the actual trust or whatever the case may be would have to come and retrieve that property. Now, what we can do is we can do an injunction to stop it, or we can do what you call a writ of replevin. Now, these two things of what I'm telling you, or you can even do a declaratory judgment, one of the three, right? So a writ of injunction, declaratory judgment, or a writ of replevin. But you have to ensure that you fully have full proof of everything that you are doing, everything. So that literally means that we got to have the legal title. We got to have the delegation of authority or certificate of trust proving that you have the authority and the trust is well and it's stated, right? That's it. Truth, proof, law, and relief, right? So once we do those things, now we're able to go into the court or arbitration, whatever it may be, and fully protect the assets. Now, again, I'm going to say this. If you're not aware of this and you don't know how to do this, then yes, you need to be in this class coming July the 26th. Because again, I've run into so many people who have paid thousands of dollars for a trust or just a few hundred. It doesn't matter. But you spent your hard earned money on it just to sit there to say, I have a trust. And then things start happening and they say, hey, what do? I got a trust. I got this. I got that. But they still garnishing my money. They still garnishing my check. They still taking this from me or they still trying to do that. And it's all because only thing you're doing is just sitting there. You're not asserting the rights of the actual the trust. They could literally be coming after you as an individual, taking the property, but the same property that you granted into the trust, and then you go straight to a court and you saying all this other stuff about the name and all this type of stuff, and instead of literally doing a motion to intervene as a trustee for the protection of the assets of the trust, and you put in these particular things within that court to protect the trust interest. You have to preserve the record. If you can't do that, that's the prompt, right? So our emergency defense, just like I was saying, when it comes to your car being towed, et cetera, the first line of defense we have is injunctions. So injunctions is the first line of defense when property is threatened. And that's what this class is also going to teach you, is how to file an emergency temporary restraining order to stop foreclosures, evictions, or bank freezes immediately. When they do these things to you, how to stop it, how to even make sure you get your money back. And if they took your money when you proved it was the trust property, then you also going to learn how to literally, right? How to literally get that plus some, okay, for the damages that has been taking place against you, right? You also will learn how to prepare a preliminary injunction request with the right affidavits and also trust documentations, right? The legal argument courts look for are irreparable harm, likelihood of success, balance of hardship, and public interest. Those are the particular things. And you need to fully be aware of those and how to go about it. So let's say a bank tries to foreclose on a trust-owned house, and you file a temporary restraining order that stops the sale, and then now you got time to negotiate or assert your rights. That's the way you want to literally go about it, okay? But you have to literally do a motion to intervene. Because let's say, and you like, okay, well, I did everything, I transferred everything over to the actual mortgage, et cetera. Well, what you always want to do is make sure that the trust has some equity in it. So do a few payments from the trust, right? Do a few payments from the trust to where it has equity into it. So you can literally do a contract with yourself, straw man, whatever you want to say, and literally do it with the actual trust, saying that you're going to give it equitable rights and interests into this particular home based upon if it take care of certain the payments or whatever the case may be, right? And then you sign it. That contract goes into full force. So let's say now the trust is paying and giving money to you to give to the actual the mortgage company or whatever to settle certain debt. All right, so let's just say after you do that a few times, so on, whatever the case may be, now the trust has a full equitable relationship into this particular property. You can't get rid of it. Not until that trust receives everything that it's supposed to receive from this equitable relationship. So as I said, the last time I spoke to you guys about this was literally, I knew someone that they were literally renting from someone who had a mortgage, and they were going under foreclosure, and they had paid up to about 7 to 8 months almost. And that individual literally went and did a motion to intervene because they had an equitable interest into that particular place by renting. And they didn't want to lose their equity after the money has already been taken, et cetera, right? So, and the other individual who was under mortgage was actually in jail. So what they did was, again, the judge ended up giving the one that was renting its equitable rights, and it let them stay there for another year and a half, almost for sure. And that's what I mean about equity. It has to be given. You're not just gonna lose just because you feel like they didn't give or whatever the case may be. So involve the trust guys. It's gonna make it easier and better for you. They have to make sure that everybody is given the remedy that they are seeking, because they can't just take away. If a person has already put their money, et cetera, and all of this stuff into it, and you know it has to be done in that particular manner to where they have to receive equity. They can't just lose their money, right? And the judge did fully honor that. So that's why I'm saying, like, it's ways to do it, but you have to create the equitable interest, right? Have to do that, okay? That also you can do that with your car, which is why I was saying that if you do these particular things, you transfer or assign these particular interests, et cetera, into the trust. Now the trust has a right in its own, using the legal title to protect its interest that it has within that particular asset or property. That's what you want to be able to do. So courts actually respect trustees who come with proper documentation, not empty claims. Okay? It's more than just talking, because they understand that a trustee has to have full record keeping. All right. And in the full record keeping of a trust is what they also consider an express trust, because everything is written, is fully expressed throughout the declaration, throughout the minutes, throughout the conveyance, throughout the assignment, throughout anything that is related to the actual trust. It's fully being written. Okay. Fully being written. Nothing is missed. All right. So we're also going to show you how to do Schedule A to list all the trusts, minutes and resolutions authorizing your major actions, and also certified copies of affidavits as well that are ready to file. Okay? Proper records means no one can say your trust isn't legitimate or that you're acting outside your authority. Make sure we can always have the truth, the proof, the law, and relief. You will win every single time. Okay? So you have to know trust law is rooted in equity. Why? Because equity demands performance. Trust demands performance from the trustee to fulfill all obligations. Okay? It has to be fairness and conscience and no technicalities. Okay? Equity regards as done what ought to be done. If your trust assigns your legal title, courts will enforce it. Okay? Equity acts in personam and in rem as well. Courts can force others to respect your rights. He who seeks equity must do equity. So that means if you're looking for someone to perform as the trustee, you have to do equity. You have to do what is just. That means you have to go and fulfill your duty as the trustee to protect the rights and interests of the trust. If you do not do that, then you can't expect equity to happen, right? So acting lawfully and in good faith as trustee strengthens your position at all time, okay? So again, how do trustees win? Well, motion to intervene when you're not named in the lawsuit. Protective orders to block foreclosures or creditor claims. Also UCCs and stuff like that. Affidavits and certificates that establishes your authority. And arbitration and temporary restraining orders or injunction to shield property before damage is done. Okay? This will literally move you from a sitting duck to just, being very powerful, pushing everybody away from you. Okay, so this is not a theory. It's literally about your actions and what you're going to do. Do you have enough information? Because just having a trust with your name on it and your assets and stuff like that placed into it is not enough. You need to literally learn. Knowing that, I got an affidavit. No, that's not enough. You need to learn the court rules and procedures and how to literally follow through. If you can do that, this is going to make this well worth it for you, okay? You're going to learn how to go from hoping your trust works to confidently defending it in court or arbitration. And this is what bank lawyers and creditors hope you never learn. So now you guys have to protect what you've built and enforce your rights. If you don't, they taking it. This is a dog world. They do not care about wrong or right. They just care about winning. Their record of winning. Okay? So don't wait until someone files a lien or a foreclosure to learn this. All right? Don't wait for it, family. Don't wait for them to lien you. Don't wait for it to happen. Get on it now. If you have a trust, start learning this. All right? If you have a trust, start learning this now. If you want to learn it, July the 26th is where we're going to be at. All right? Trust administration. It's also going to come with a few other classes that I'm adding to this to help you out, which is also an asset protection and private administration, which is also going to show you the step-by-step on how to get the remedy that you are seeking when it comes to these particular companies and things like that, and protecting the asset. So when you do the private administration, what it's doing is it's building your evidence that is going to help you along when you go into these courts to deal with certain things, or even arbitration. You want to be able to build the evidence, right? So basically you're getting a 3-class-in-1, 3 ebooks that comes with templates and everything else that you need. All right. Live stream is $200. In person is $250 as well. And just know, screenshot that if you have the chance to, so you can keep this on your mind. Go to ingodwetrustacademy.com. All right. Now that's just that class now. August the 9th. We're going to be talking about money. The hidden ledger. Let's talk money. Let's talk about it, right? Let's talk about what this means. Every time you deposit money or sign your name on a check, you create value that fuels the banking system. Okay? The banks multiply your money. They lend it out and they pocket the profits while you get nothing but a digital balance on a screen. So just remember, at the end of the year or first of the year, whatever they do, they put like maybe $1, a few little change in your pocket over the year just because they saying this is what you got in interest. Yeah, so imagine how much money they've made off you and they gave you pennies for it. Yes. And as long as they gave you some form of little small interest off of it, then it is considered to be equitable in their standpoint and eyes because, one, you never made a claim to it in the first place, right? Never did that. So what is the Fed? It's not truly a governmental entity. The 12 regional Federal Reserve banks are privately owned corporations controlled by big banks. So that means that all the other small banks like Wells Fargo, Bank of America, Citi, things of that nature all have what they call a share in one of the 12 regional Federal Reserve banks. And the Fed issues FRNs, Federal Reserve notes, but these are debt instruments and not lawful money like gold or silver. But however, they are lawfully considered legal tender. Okay? So how money enters circulation? Right? How does money enter circulation? The U.S. Treasury issues bonds. They're really what they call government IOUs. And the Fed buy these bonds with credit, all right? And it creates out of thin air and then gives the Treasury FRNs to spend. These FRNs circulate as debt public, all right? As debt to the public, right? And the public must repay this particular interest. So every dollar in your pocket represents debt owed by taxpayer, not real money. And the more government borrows, the more debt we all owe. And the more they borrow, well, the less value the dollar becomes, right? Because like even now, I was looking to where they was talking about NBA players today, how much money they make compared to, like LeBron's getting paid $52 million next year. $52 million. That's like some of the best players. That's the most money they ever earned in the 90s out of their whole career was 50-something million, $60-something million. And a lot of y'all be like, oh man, they getting paid. No, actually, it's what it's showing you is the dollar has lost its value. It's not that they getting paid so much, or the big difference is they made more money. It's not even really that. It's just the dollar has less value. So they have to pay these players all of this amount of money due to the cost of living and the loss of inflation of the dollar, right? That's the difference, because 52 million in the 90s, it was like having 200 million. That's the difference. So now you can imagine having 52 million today and literally what it is, and, operating from that. So that's another thing that we have to realize. So how does your deposits feed the system? When you deposit money, the bank takes ownership of your cash. And on the bank's books, your deposit becomes their asset. All right. And your account is recorded as their liability, which means they owe you the amount you see on your balance. Now, here is the question. They owe it to you. I want y'all to pay attention to that. So what they're saying is, if anybody's saying they owe you something, then they got the right to use of it. Now, mind you, this is a creditor-debtor relationship then. This is not a trustee relationship, okay? So that means that it gives them the right to use this money since they owe you, because if you give me some money, I borrow the money from you, I'm going to use this money for whatever specific reason I want to use it for. Just know that I owe you. So that's reason why if you do a $10,000 check, they not finna let you take $10,000 out. They might let you take $1,000. And say, hey, you can come back and get the other 9,000 within a few days or so. They might tell you wait 10 days, 7 days. That's because the money is under fractional reserve banking. So that particular money is going to be used to create more money. So banks use your deposit as reserves, family, allowing them to legally lend out up to 9 times the amount you deposited, which is called fractional reserve banking. They charge borrowers interest on this newly created credit, okay? And now they're keeping all the property, y'all, while you receive nothing but a few little pennies, nothing beyond your original balance, guys. And that's why at the end of the year, they'll put $1 or something in there, maybe 50 cents, 30 cents. You all done seen it happen. And that comes from them literally using your money. A bank works like a 401k. Yeah, it does. So if you deposit $10,000, the bank can legally lend $90,000 using your money, earning interest on that $90,000 while you earn nothing to maybe a few pennies. Yeah, that's how they do you. So generally accepted accounting principle requires banks to record deposits as liabilities and treat the money you gave them as their asset. Okay, well, under the UCC, it defines your signature as negotiable instrument, and credit event banks can monetize those particular negotiable instruments, right? This is all perfectly legal, but only if you don't object or set your own terms. So if you don't object and set your own terms, and remember, everything that happens has its own default mechanism, right? Like if you go into a bank, they have what they, by default, certain accounts they automatically gonna set you up with by default, unless you get to asking questions and saying how you want your account to be, et cetera, and all of these different type of things, right? They'll make you an offer. You got a right to negotiate at all times, but we don't. We just go in, I need a bank account, get a bank account, boom, boom, done, whatever. You go about your business, right? You never ask about a non-interest bearing account for a trust. You never ask for it to be set up in a certain type of way or things of that nature. We just get it and go. So in the world of commerce, there is a default of how things actually are going to be presumed of what you want and how it's going to work until you say something different. Okay? So you have to understand that silence equals consent in banking. And if you don't assert your rights, the bank assumes you donated your value. Well, did you donate it? You ain't say nothing, because by default, they can consider everything was a form of a donation at the value of it, right? So in this particular class of what we're going to be showing you in the hidden ledger come August the 9th in Missouri City or in Houston, Texas, as I like to say, because it's just on the outskirt. You're going to be redeeming things in lawful money, preventing your funds from becoming debt instruments, and opening a trust-based account. Or you can even do it as a 508 if you have one of them. And this will let you control the terms of your banking relationship from the start. So you're going to learn how to deliver a notice of terms and condition of deposit that declares. Now, why can you do this? Because it belongs to the trust. The trust gets to say what happens to its property because it's all in banking and barter relationships now. So now you're not donating your value. You retain equitable interest in the credit created from your deposits, and silence from the bank is accepted by conduct. So sign every deposit with endorsements as well. And remember, this is for value contributed. We are giving contribution. And they're going to take the money because they want to use it and continue doing what they're doing in the first place, right? They're going to do it in the first place. So learn that. The power of invoicing and the UCC filings, right? So we can also create what we do, invoices. Send invoices to your bank demanding your equitable share of the profits they earn using your deposits. You can place these on there. We can also file the UCC based upon the actual relationship that you're having. And you can declare yourself as the secure party. And you can also literally you can do the secure party as the actual trust and the bank as the debtor, and listing your deposit signatures, instruments as collateral. This creates a first in line claim. And if you ever need to enforce your rights, you need to make sure that you're able to do that because you have the right documentation. So imagine sending an invoice to your bank, $900, because your $10,000 deposit helped them lend $90,000. Then backing it up with a UC filing that says that you're the first in line for that particular value. Understand that. And they have to give it because, remember, it's already yours. It belongs to the bank, to the trust. And the trust has the right to claim its rights and interests in any form of its property as well. So if the bank starts to do things, ignore you and all of that type of stuff, you can do notice of fault and opportunity to cure, notice of default, and affidavit of non-response. All of this is considered your facts and evidence for if you have to go to court for any type of situation. But again, if you go and sit down with these people and talk to them in the right, correct manner, they will give you certain documentations to help you do this in the first place. Yes, you must create a deposit account control agreement as well. That will also go along in it. So you got to understand that the trust ledger is everything for you. So turning your trust into a private financial engine, you need to keep a trust ledger tracking every deposit that you make, the estimated credit created, invoices and responses, issue certificates of value contribution, recognizing each contribution as a trust asset, like internal currency for your community as well, and to use your trust to offset liability with notices of offset, how to issue private contracts to manage assets and community projects, also fund schools, clinics, or land acquisitions privately and lawfully. When you operate your trust like a private bank family and you take back control from a system designed to profit off your ignorance. And we just taught the People's Private Banking class, June the 20th. So this will also help you guys that took that class. And if you didn't take that class, you missed a great class in learning how to set up and operate through your own form of private banking. Very dope class. All right. So what you guys got to understand, if you really want to know how to operate, because just saying that you're a trustee, because if you're the trustee of something on a particular trust, you need to learn how to generate the wealth. You also need to learn how to protect it. Everybody always just want to know how to create the money, etc. But can you protect it? Can you protect the rights and interests of the trust? Can you go through a full court setting, all right, as a trustee without hiring a lawyer, spending extra money from the trust, being able to fully protect the rights and interests of the trust? Can you do that? Right? Ask yourself that question right now. Do you understand the rules and procedures, even through arbitration? Do you understand fully of all of your contracts? Because as the trustee, you're supposed to. All right? You're supposed to. Have to. So if you're tired of banks getting rich off your value while you struggle, then join us in the Hidden Ledger class, and you'll learn the lawful steps to reclaim your equity, family, and enforce your rights and build wealth. That's what you want to do. Build your private wealth the way you can't be touched by public systems, and don't let silence cost you your legacy. Knowledge isn't power until you act on it. So just having a trust with no knowledge and wisdom of it, etc., knowing how to protect your property is the problem. Okay? That is the problem. So how many of you guys are literally tired of just giving your money, putting it in the bank using your property? Like, let me flip it in a different way. Imagine you giving me your car, allowing me to use your car, and I take your car and I go make $1 million with your car, and I only paid you $300 to rent and use your car. What about that? How would you feel about that situation? Knowing it's just like you giving somebody $1,000 to go into the casino, right? To see if they can win stuff, right? And if they go in and they hit, let's say they hit, you gave them $1,000, they hit for $3 million. Are you gonna want your money? Are you gonna want some equity out of that? Or you just gonna, you know what I'm saying? Or you just gonna let them ride? No, you not. You're not just gonna let them ride away. Like, man, I gave you $1,000, bro. You better at least give me $1 million. You can keep the other two because you did your due diligence of hitting. You know what I'm saying? Some of y'all might want the $2 million and allow them to get $1 million. Either way, it don't matter. They got more money than they started out with, even with just $1,000 alone. So that's the same situations with the bank. You're giving them the money and they taking it and they like, I'm finna go over here and make this money. Come back, pay you. It's no difference than, let me put it in this language. It's no difference than somebody being fronted from the plug, making the money and then taking the money going to somebody else, using the plug's money to make extra money, and then you go pay the plug off, but you give them no interest based upon you using their money. Same type of situations, and you know y'all do that out there because y'all ain't got no morals or equitable insight within yourself. So it's the same situation. You do it. But if you really want true equity, somebody said get knocked upside the head. If you really want true equity, then do the right thing, Spike Lee. You know what I'm saying? Do the right thing. Do what you're supposed to do. That's absolutely correct. We can run the 80-20 rule. 80% for you and 20% for the bank. Either way it goes, there's still money that the bank gets to do times 10 and still create more money and lend it out. They still get to do it. It does not stop them, right? We need to learn more about the bank than just the bank holding your money and you swiping a card. The bank can do so much with you. You can bargain and use and do things with the bank. All right? You can do that. But you have to learn how to fully operate in that manner. Right? You have to learn how to operate in that manner. And that's what matters the most. Now, this is the thing. Since we're speaking on trust, banking, and stuff like that, it's funny, man. And I never understand a lot of y'all. Like, I'm the type of person, if I don't agree with somebody, I don't like what somebody's doing, I just don't pay it any mind. I don't care. It doesn't faze me, doesn't whatever. But a lot of you guys like to put up a lot of freaking arguments. So, this particular travel pass here, all right, this is under trust obligation of MNRP. A lot of people have asked, hey, how do I get that? How do I get your passport? For number one, you got to be a member of MNRP to use the assets of MNRP, which is these passports, right? So What I'm trying to tell you is this, and that's why I was like, oh man, nobody's going to recognize that. Listen, number one thing has to do with this. Yes, issue a 1099-B to get your funds back. Absolutely. We're going to go into that more too. But a lot of people need to understand this. And I'm saying this, and I'm saying this from on a higher level for you guys to understand. It does not matter what anybody thinks. It's about what you think. Do you recognize you? Do you recognize what you're doing into your trust and all these things? Do you recognize it? All right. Do you have truth proof law for yourself in this particular manner? That's what matters. It's going to be a lot of naysayers about a lot of things that you guys are going to do, right? But when it comes to MNRP, we have multiple different forms of identifications for certain specific reasons that we've used in courts, cases dismissed and got on airplane, whatever the case may be, all right? But the thing is it's because we are the trustees. And as the trustees, it's our duty to protect our assets, our rights, our interests, etc. It's nobody else's decision, family. It's nobody else's opinion about any of this. People gonna say whatever they want to say. I promise you. Even some of the closest people you might think you cool with gonna say shit that you just not gonna like, or they gonna see something and deny it or whatever. It happens, guys. I promise you. So don't let that disturb you. Don't let that deteriorate you from what you're supposed to be doing. What matters is truth, proof, law. And you can be guaranteed the remedy and relief that you are looking for. Every single time. Every time. It's going to happen. All right? If you guys understand this, what I'm telling you, then you're going to know how to operate with everything that you are doing, no matter what it is. Just make sure you can prove it. You know what I mean? That's all that matters. Now, yes, I know that there's a lot of organizations and different things like that, or sovereign movements and that says this and they do things out of wrong capacity. But hey, it is what it is. That don't mean it puts you in those same categories. All I'm going to tell you guys is fact check everything that everybody's saying and doing, including myself. I don't mind being fact checked. If you find some type of flaw in my work, man, tell me. I like to be corrected too. I'm not so high above myself to where I feel like that I can't be corrected on a matter. I can't be told something. I can't be taught something. I don't never feel like that. I wouldn't got where I'm at today if that was the case. Because what I do is I study others. I study myself, I study for myself, and I study others. If it works for you and I see how it works for you, and I study what you do and how you move with what you do, and I find out that it's going to help me in what I do, then I'm going to use it for myself as well. It would be dumb for me not to. I think we all need to be on that. And again, here's the thing. I would never tell you, oh, that's not going to work. I don't believe in that. I'll never tell you that. I won't say a word. I just won't use it if I don't find it beneficial for myself. Or I'll find a way to use it for myself in the way that I do things because of estate planning. It's a plan. It's your plan. Everybody's trust is not going to be alike. Everybody's situation is going to be different. There's literally no two trusts that are alike, right? Once you understand that, then it is what it is. Find your way. I didn't want to go do an LLC and an irrevocable trust and a revocable trust and a holding company and all of that. I didn't want to do that. I don't have to, because I can literally just operate like I showed you guys once. I showed you how to operate from a 508 and using a trust, irrevocable trust, and you can do any and everything. You can literally create departments within your trust to do everything else that you're trying to do. You can do it. And if you wanted to go create a trust, let the trust create the business, let the trust create the business, and the business operate fully for funding of the trust and the 508 or whatever that you're using to help keep it tax exempt. Make sure that you give all money that you so-called profit off of, that you donate every single penny to the actual 508 or the actual trust, however it is that you're operating. That literally makes you tax exempt. That literally places your business under the 508 as an auxiliary as well. But that's how I operate because that's my plan. That's the plan that I created to understand for myself. It's all about understanding. Stop going out here and following everybody's procedures and stuff if you have no understanding of it. Understand why they're doing it. I came up with my own method because I understand what I want to do, how I want it to work for me, and how it establishes and makes it easier for me. One, I don't want to be filing income, tax returns for 5 different freaking entities. I don't want to do that. I don't got time to do that. You know, a lot of people do though. They get y'all all this stuff. I talked to some people. Yeah, I created a trust last year. Now I'm creating this trust. I got a family trust. I got my own private trust. Why do y'all, if you got a family trust, then put everything in the family trust. Just learn how to use the conveyance. The conveyance itself will literally say what is to happen to whatever particular property that individual is placing into the trust. So you literally, it's like you get to write the rules of the use of this property. Same way you wrote the Declaration of Trust. So why would you have to go create a whole full separate trust for that particular purpose when all you can do is literally put it in there in the conveyance exactly how you want to do something? That is the easiest thing ever. But if you just want 5 to 6 different trusts to do this, to do that, then fine, do it. You see what I'm saying? You know, and that's how I look at it. I literally feel like things could be so much simpler. I'm not saying there's nothing wrong with other way people do stuff. It's perfectly fine if they understand the plan they have created to operate these different entities to do the things that you want them to do. It's fine. Right? I get it. But the thing is if you don't understand it, and y'all going out here letting people create your trust and you don't understand it. That's why if I do your trust, I'm asking you, what is it that you want? What do you want to happen? All right. And in the midst of me putting it together, you're going to read it. You're going to read everything in every paper that it is that I have given you so you can know what to do. You're going to have consultations. You're going to be able to ask me questions because I want you to know what you are doing. I'm not just going to hand you a package and say, here's your trust. Have a nice day. Defeats the purpose, especially if you're finna go be the trustee. I just set you up for failure. I know you're going to fail because you don't know how to operate it. I run into that all the time, right? I run into it all the time. And then if you got a trust, you don't need my trust. You don't need to set your trust up. A lot of y'all just want to go redo a trust. You don't have to. There's nothing wrong with your trust. You just haven't read it. Read it. Understand it. Don't make a move until you do. But most of all, learn to protect it. Learn to operate within its capacity to make sure that all assets stay home. That's all that matters. Anything else, guys, is going to leave you in form of despair. And I really, 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 really have to say that to you guys because it's different. So that also means that you need to also know how to do appeals. If you have to appeal for a basic reason on the trust, lawsuits for a trust, you need to learn how to defend in courts for a trust. All of this is important for you to know how to do. And if you don't do it, hey, it ain't my fault. It's yours. And everybody's screaming, oh, I got a trust. I'm the trustee. That's beautiful. Let's see what happens when shit hits the fan. Let's see what happens when you got to make different movements and do certain things, right? Let's see what happens. Because if not, that's where everybody falls short, is learning the rules of the game and how to literally operate in the right capacity. And when you do this, that's where the trouble comes in at. Right? So I just want to make sure everybody knows that, man. Not gonna hold up too much more of y'all time. Y'all gonna see my face maybe one more time later on tonight sometime. I gotta get to feed my family. But as you guys know, we got 2 classes. All right. Trust Administration, July the 26th. And then we also have August the 9th, the Hidden Ledger. So go to ingodwetrustacademy.com. Again, for those of you who don't know, it's plenty of different classes on there. We actually finna get ready to do a sale on some things. Make sure that you get added to the email list. So admin@ingodwetrustacademy.org. Again, admin@ingodwetrustacademy.org. Get added to the email list so you can see the discounts and things like that that will come out with these different classes. Remember, Trust Administration has 3 classes involved. So Trust Administration, the private administration, which literally shows you step by step on how to, send letters and do things like this to build your evidence up for it with these particular companies, courts, et cetera, whatever the case may be. And then you also have asset protection as well, which is also going to show you it's like a it's like a part 2.0 for this particular trust administration. So there's 3 different ebooks that's going to come with this, a whole lot of information, and it's going to be up to you. So I'm the type to give it all to you. It's up to you to do what you're going to do with it. If you want to learn it, you'll truly learn it. You'll truly sit down. It is a step-by-step situation for you in every manner, but it's totally up to you. I'm not making nobody do anything that you don't want to do. All right. And also the Hidden Ledger. This is where we'll be to as well. But I'll catch you guys later on today. Lock in with us, man. If you guys got anything that you want to talk about, don't hesitate to send me an actual email message or whatever the case may be from social media. So, we can chop it up, touch some of y'all subjects that you want to get on and things of that nature, man. Again, appreciate you. Yeah, man, I'm coming to Florida, so make sure you come, Coach Tammy. Yeah, be in the building with us. We'll be there for about 5 to 6 days. I'm gonna be there with family as well too. So a lot of my family members and stuff like that. We were just taking a trip to Florida, and I just decided, hey, why not do a class and give the people the opportunity in Florida in that particular area and stuff like that to come through and rock out with us, man. So yeah, appreciate y'all. And again, I'll catch you guys later. I think we're gonna do a giveaway later on today. So make sure y'all lock in with me, right? We will do a giveaway later today. All right. I don't know the time. Just know I will be on here. If anything else, I will be on here by 9:00. 9 p.m. Central Time. All right. Y'all have a great one. I'll catch y'all.